I welcome much in this bill. I welcome the investment in legal aid, the additional sitting days and the funding for our courts. But I want to focus my remarks on two proposals within it: the restriction of jury trials for either-way offences and the removal of the automatic right of appeal from the Magistrates' Court to the Crown Court. I say this as someone who began their legal career as a prosecutor in the 90s, when the kind of backlogs we see today simply did not exist, even though in those days more cases were heard in the Crown Court because the magistrates had the sentencing power for only 6 months. The delays we face today are not caused by jury trials. As Shadow Justice Minister, I remember repeatedly challenging the previous Conservative government about the consequences of the decisions they were making. Courts were closed, judicial sitting days were cut, court staff were reduced, and legal aid was placed under enormous strain. At the same time, the system had to cope with demands of modern digital evidence, delays in disclosure, problems with prisoner transport, and the disruption caused by COVID. Now, the government argues that these reforms are necessary to reduce the Crown Court backlogs and often point to the delays faced by victims of sexual and domestic abuse. I take these concerns very seriously. A substantial part of my career as a prosecutor was spent as a designated child and sexual abuse specialist and rape specialist. I worked closely with victims, witnesses and families affected by these traumatic offences. If I believed that the abolition of jury trials would generally allow these cases to be heard more quickly, I would support it. But I don't. There is also an issue of removing the automatic right of appeal from the Magistrates' Court to the Crown Court. This change will disproportionately affect the defendants from poorer backgrounds who may not have legal aid representation. We know that a significant proportion of these appeals succeed, which raises serious concern about access to justice. These two proposals will disproportionately impact the most vulnerable in our society, particularly those from socially, economically and educationally deprived backgrounds. My own constituency ranks as the 38th most deprived in the country. For many of my constituents, the criminal justice system already feels distant and difficult to navigate. We should be careful not to introduce changes that risk criminalising and disadvantaging them even further. There are real reforms that could be done which could address the delay. The first and foremost is the Labour Party's commitment to have specialist rape courts, properly funded, and I know that lawyers and judges will be prepared to sit weekends to tackle those cases through. Secondly, we could be more like the civil system, where there are particular timelines which are set into the case so that cases are progressed properly, and if any of the parties don't act properly, there could be financial sanctions to them. Also, I know we're going to be opening more courts and courtrooms, but we need to expand the judicial sitting days as well. We also need to make sure that the SERCO and other bodies that produce defendants in courts, those contracts need to be reviewed as well, because there's a lot of delay caused by defendants not being produced at court. Further, we will say that the prosecution and the police need to be able to present their evidence to the defence as soon as possible, and for the defendants to be legally represented so that new additional evidence can be considered so we can have pleas done at a much earlier stage. I think that we need to look at these things first, try to put these things into place, and then see what happens before we get rid of or restrict jury trials.
Slade. Thank you.